Hi everyone, it's Amy here from the blog I Think Therefore I Teach. Welcome to your next Criminology instalment. This one is for Unit 3 and it is 2.5. So, let's get going. Alright, so Unit 3, Topic 2.5. This is the final of your twos within Unit 3, and this one is discuss the use of laypeople in criminal cases. Do not forget when you're making notes from these PowerPoints to always paraphrase or put into your own words just so that it is appropriate for your controlled assessments. So think about what advantages might there be in having your case decided by members of the general public rather than a judge. So I got my students to think about, why do we actually have juries? Why is having a jury a good thing? Because obviously the jury is made up of lay people. A lay person is somebody that is not qualified within the legal field. A layperson is someone that does not have training or degrees and specifically within those areas as well. So what's the advantages of using laypeople within the jury? Why might members of the public not be fair when deciding on a case? So what are the good and bad things about having a jury? So I've got my class to first of all think about and then discuss what these might be. Are there any other disadvantages to members of the public deciding the verdict in criminal cases? So what you might want to discuss and consider is the fact that by having 12 people, that's a good number from a variety of backgrounds and understandings, and that they can really approach your case from a normal human being's perspective. I'm not saying lawyers and etc. are not normal human beings, but they get called to the cases. For them it's a job, for them it's worth money. So there's reasons why the prosecution and defence do what they do. A judge, again for example, he'll see or she'll see these cases again and again and again, and so they become hardened to it, whereas a jury is completely new, they're completely fresh. They will take everything on board and come from it from a different perspective. However, the disadvantages of using the public, why it might not be fair, is because they aren't trained. They won't necessarily understand all of the material that's being covered. They won't understand necessarily the ways to approach it properly or how to process the information. Some of the information might be too complicated or too difficult. They might also look at things that could really go against the individual, so they might judge the person based on their own personal biases. They might judge the person based on how they look or how they present themselves rather than what the evidence actually is. So there's many pros and cons with the jury that you need to consider as we do this. What we need to study then is lay people are ordinary members of the public, so you and me are lay people, without any special professional knowledge of legal matters. In our system, we have magistrates and jurors, and so the discuss element of this topic is you do need to weigh up the pros and the cons, the advantages, the disadvantages, the good things, the bad things, the strengths, the weaknesses. So that's the language you have to explicitly use within this topic. You can't just say, you can't just imply that because they are members of the general public that this is automatically a good thing. You have to actually specifically say why it is a strength of using a jury and using lay people. Lots of good support as well from case studies is appropriate within this topic. So, juries. After each of the bullet points that I'm going to go through now, I've got my students to leave a couple of lines of gap. So once you've written down each point, go through and then write down how each one can pose as a pro or as a con. So I've got them to write down the bullet points I'm about to do in a second, and I got them to leave a space between them, or they could split their page. So they write down one side and leave the other side free. So you can use your notes as you would like. So what do we already know about them? This is the general what are juries. They hear Crown Court cases. There's 12 per case to try and reach a verdict. So again, I got them to leave a few spaces. They are ordinary members of the public, leave a few spaces. Randomly selected from electoral register, aged 18 to 75, must have been a resident of the UK or Commonwealth for a minimum of 5 years with no criminal convictions for 10 years. Usually they serve for 2 weeks but can be longer. The law says you must do jury service if you're asked. Juries Act of 1974 and the Criminal Justice Act of 2003. But you can ask to be exempted, for example, for medical reasons. Juries hear the evidence presented by both sides and then retire to consider the verdict. Criminal Justice and Court Acts of 2015 states that it's a criminal offence to ask a member of a jury to talk about how the verdict was reached. And then I got them to watch the clip at the bottom to see if there's anything else they could pick out. But again, if you just do a general YouTube search, you'll find lots of videos that are useful online. So from here, this is the juries. And I got my students to look at each of the statements, each of the bullet points, and work out why it's a good and or a bad thing. So, for example, why is it a good thing that they start at 18? Why is it a bad thing that they start at 18? 75. Why 75? Why not 80? Why not 70? Why 75? So again, why is that a good thing? Why is that a bad thing? What I'm not saying here is that there may be pros and cons for each one of them, but you need to think about what the pros and cons might be. The idea that they have to do jury service. So once you've become 18, if you are no longer a student, so if you go straight from your college into your employment, you could ask to be part of the jury service. They pay you, but they don't pay you the same. So sometimes, for example, people might actually get paid less during their jury service. So why, again, is it a good thing or bad thing that people cannot get out of it? It's a good thing because otherwise people would just say, oh, it's not convenient for me, I don't want to do it. So you'd always get the same sorts of people going up to be a juror. So it's a good thing that you can't get out of it. But then the bad thing is they might be sat there thinking, I don't want to be here. How long is this going to take? So again, they might not come then with the right attitude. 12. Why 12? Why is that a good thing? For me, I think that 12 it's quite big. It's quite a big number. It's quite a lot of people. But 12 is a good number. You have a lot of people there, different genders, different backgrounds, different ages. So there'll be a lot of representation within that jury with there being 12. It also means it doesn't rely on just a small group of people to make the decision. Etc. On members of the public, I've already said about a few good things and bad things about that. You know, the fact that they can't have any criminal convictions for 10 years. Why is that a good thing? Why is that maybe a bad thing? So work through each of these and come up with what is good and bad about them. Some of the strengths you may then have considered is the idea that they're democratic. What that means is that within a democratic society that we live in, where we have a vote system, people are tried by their peers. So you are tried by other people. And in a democratic society where your vote and your voice is important, so why shouldn't it be also your voice and your vote important in legal matters? It's not the privileged elite. What I mean by that is it's not the judges that have been to Eton. We're not talking about magistrates and not necessarily magistrates, but barristers and lawyers that again have been highly educated. We're not talking about the elites. We're just talking about you and me, normal everyday people. So they're a mini parliament of ordinary people. They hopefully work towards a balanced decision making, so fairness. Decisions about guilt and innocence rest on the views of 12 people, not just one. Different views have been carefully discussed and considered. Jury equity, these words are all important, especially for later on as well, they come back in. They bring everyday wisdom and fairness, so if necessary, they can decide it's morally better not to apply the law. Now, this is a topic we do in 3.2, so your last topic you look at this in a bit more detail. But what it means is that a jury do not have to necessarily follow the law. If they believe in that specific case the more moral thing to do, the fair thing to do is to let them go, then the jury has the final decision. The judge cannot overrule the jury. As we learned in the previous topic, the judge can have, it's in 2.3 or 2.4, I can't remember which one it is, but we look into the jury can really coaster a jury down the route that the judge wants to do it. But at the end of the day, the jury, it's their decision on whether they are innocent or guilty, and the final decision lasts with them as well. So there's a lot of pressure on a jury, but it also is taken very, very seriously. They're not just there to give their opinions and then the judge makes the decision anyway. No, the decision lies with them. That's quite important, is that. So they see things from a normal everyday perspective. And there's a few cases that come up in a few topics' time, but the few that my students looked into and researched, there's one to do with somebody that leaked, I can't remember what the case was called, but it's someone that leaked, whistle blew on a company, and what they did was they broke the law when they whistle blew and they released all this important private information, etc. But the jury found them not guilty. They used their equity within that to say, actually, they did the public a service. Yes, they broke the law, but they did it for all the right reasons. They have a lack of bias. No one on a jury can be related to anyone else involved in the case being heard. And they're not case hardened, which I've already mentioned. Juries serve for a short time only. They won't be jaded or hardened by cases, which judges and barristers and lawyers might be. Weaknesses, however. Sometimes they make really puzzling decisions. Juries do not have to explain their decisions. Sometimes they seem to defy the evidence that has been presented. So they can come back with whatever they want. And sometimes you'd think, this is all the evidence, yet you've still found them not guilty. They don't have to explain how they got to it, though. So the 12 juries, the 12 could sit in that room and every single one say, don't really understand anything that's been said, let's just say not guilty. Absolutely fine. They don't have to explain themselves. Hopefully that wouldn't happen, though. They're not experts. They are not expected to have law degrees, any expertise or basic level of education or intelligence. Sometimes trials are complex. They don't even have to have passed their GCSEs. They don't have to have passed any sort of formal education. All they have to be is on the voters' roll. That's it. So some of these things might be very complicated, and obviously it's very serious as well. They've got a very serious role to play, and some people might not be up to it. Prejudices. Ordinary people can have pre-existing prejudices such as racist views, so their opinions could be biased and discriminatory. The internet and social media, this is a massive one. It comes up all over the place, doesn't it, within these topics. Jurors searching the internet for information about a case before or during a trial. Their views may not be based only on the evidence presented in court. This is against the law, but 12% admitted to doing it, which was a study by Cheryl Thomas. How can you not Google the person? How can you not notice a newspaper where the person might be splashed all over it? And how can then opinions then not affect the way that you make your judgments? So we've looked at many cases where the media has had an immense effect on the way that we see people. Christopher Jeffries, for example, Jeremy Bamber, all these people, George, what's he called? Barry George. The way that the media portrayed these people within the newspapers and picked up on all their, their personalities and their behaviours. If a juror reads this, it will subliminally go into their minds. They'll remember these things rather than just looking at the evidence in front of them. And as we know from a previous topic, it should be all on the evidence. Jury tampering. Members of the jury can be bribed or intimidated. And then I got my students to check out the Ouija board case in the trial of Stephen Young, when the jury used a Ouija board to come to their decision. So again, it shows how when they don't have, for number two, when they aren't non-experts, they might do things that might be seen as completely unethical when coming to a decision. What do you then do? Magistrates. Once again, I got my students to do exactly the same thing. I got them to leave a space between each of the bullet points so they could look at the pros and cons afterwards. What do we already know about them? About 15,000 of them serving over 280 courts around the country. Unpaid part-time volunteers, sometimes called Justice of the Peace, the JPs. They get some training but aren't legally qualified. They have a legally qualified clerk, though, who advises them. Aged 18 to 65, serve until they're 70. Almost all cases start in the magistrates' court. 95% are decided there. Usually there's 3 magistrates that hear a case. Less serious cases such as motoring, shoplifting, damage and disorder. Some specially trained ones work in youth courts so that they hear the everyday things. Sometimes if a case is so severe, it'll just jump straight to the higher Crown Court. They can impose fines up to 5,000 or 6 months in prison, so they still have some power, but we're talking about the less serious crimes. Sorry, please ignore my house phone if you can hear it. I then got them to watch the clip as well to add in any extra details that they might have come across during from that clip. Working through some of these then, there are strengths and weaknesses that can be drawn from a number of these bullet points. So, for example, the strength is that they always have a clerk that's qualified there to help answer any questions, to direct them down certain specific areas. But the weakness is that they're still not trained, they're not legally qualified, and they're still making decisions about giving someone 6 months in prison. Another strength or potential weakness is that they're unpaid and part-time. That can mean to both strengths and weaknesses. So the fact that if they're unpaid and they're part-time, they're unpaid, which means that there can be no bias, there can be no bribery, they don't accept money of any sort, so that makes it a lot easier. It doesn't cost the country any money either to have them. They're volunteers, so people can again volunteer to be part of the process. So it's a really good thing. For example, if you are doing a law degree, doing this as part-time experience, the fact it's part-time also means that more people will be able to approach and do it, because a lot of people work part-time and therefore will have a bit of time, whereas if it was full-time it just wouldn't work. The weaknesses of that, however, are if they're unpaid, what's the word, incentive do they have to actually do this? What incentive do they have to turn up on a morning for the cases? If they're also doing this as part of being unpaid, what sorts of people can really afford to be a magistrate and not get paid for it? Is it a certain group of people that have already a lot of money so don't need to work, or have rich partners so they can, do this on the side? So you've again got to think about most people cannot just give their time up unpaid to be a magistrate. So what type of people are we talking about here? So again, work through each of these and try and come up with some good things and bad things about them. Oh, and they can double this for multiple offences as well. So they can double their 5 to 10 and 6 to 12. Some strengths then that you might have talked about is democracy. It allows ordinary people again to become involved in bringing justice rather than just leaving it to the state. So they're ordinary people once in a while because they're not legally trained. They'll have some legal understanding, but they're not legally trained. Local knowledge, they have a local insight and can apply this to cases and have local needs and concerns in mind. So this is a really good thing. This is a huge strength of them, in that your magistrates are in your local courts. So they'll be local people, they'll be local to the area, they'll know what will benefit the community. So they'll really bring an understanding of what's important. Representative of the population. In 2018, 12% were from BAME backgrounds. The UK population is 14%. So that's a significant statistic. 12% of them are from BAME backgrounds. And our national statistic is 14%, so that's really high compared to the national. 55 are women, whereas UK population is 51, whereas with judges it's only 29% female and 7% BAME. So the magistrates, 55% of them are women. You've really got the woman's voice in the magistrates then, whereas obviously judges, a lot fewer are female. Limited number of appeals. They deal with many cases, 1.5 million in 2018, so that's a lot of work. But very few go to appeal, 5,000 per year on average. 5,000 when you're talking about 1.5 million is not a lot. Most are appeals against sentences, not verdicts, so they accept they're guilty, but they don't like the sentence they've been given. This suggests magistrates are getting it right most of the time. And cost, it saves us money. They're unpaid volunteers, so we estimate saves around 100 million per year. That's immense. Weaknesses, however, they don't necessarily represent the population all that great, in that yes, we may have BAME and female, but gender and ethnicity is good, age and social class are not. Only 4% are under 40. The population is 50%, and 55 are over 60. 55% are over 60. Of course they are, because they're the people that have the time to do it. They're retired, for example. So, of course, not only 4% are under 40, whereas obviously half the population are under 40, because people under 40 as well have dependent families, they'll have full-time or demanding jobs, etc. So even if they're part-time, they might still have to work a lot at home. So 55% are over 60. They tend to also come from middle-class professional management backgrounds. Why? Because they're then interested in things like the magistrates. If you retire, or if you're in a part-time job, but you have no interest in legal matters at all, why would you want to volunteer for magistrates? So it's the circles that you move in that might lead you towards doing something for your community, or, you know, use it as bragging rights. Oh, I'm part of the magistrates. So middle class as well, because they can afford to do it volunteer. More well off are better able to work part-time and take time out to volunteer. So again, what implications does this have, or what implications on issues does this have towards trials, the outcomes, etc., if they're mainly over 60 and from middle class backgrounds? Inconsistency of sentencing. They should follow the sentencing guidelines so that similar cases are treated in a similar way, but the evidence doesn't show this always happens. So, for example, in Bristol Magistrates 2010, the custodial sentences, 11.1% of offenders and community sentences were 32.2%. So 11.1% were given custodial, whereas other community sentences were given 32.2%, whereas Coventry was only 68% custodial and 14.4% community sentences. So is it just the areas, or is it the magistrates making the decisions? Bias. Magistrates convicting over 90% of cases. Some say this is because they are case hardened and biased in favour of the police and prosecution, tend to get to know the local police and CPS solicitors. Basically, 90% of cases they find the person guilty. Maybe because 90% of them are guilty, or maybe because they listen to the police, they listen to the background things. Like for the strength on the previous slide about them knowing the area, maybe they know of that name and know that they're a problem. So yeah, let's find them guilty for this because we know they're an issue. We might not have a lot to charge them for this time, but we're going to do it anyway. Finally, over-reliance on legal advisors. As the main legal expert, they may have considerable influence on the magistrate's decision. They have one legal expert, and so that person might have significant influence on, again, leading them down a certain path or decision. Okay, so for this one then, you just need to know about the lay people within the jury, the lay people within the magistrates, and then why that is a good or a bad thing. So hopefully this has helped you. Do not forget you have to explicitly use the language, a strength of this, an advantage of this, a positive of this, etc., pro of this, etc. So and make sure you use a because. Make sure you explain the bits that I've done verbally in your answers as well. Don't forget to change this into your own words when you're writing it down. But please feel free to use the different ideas that have been shown. If you like this video and you find it useful, don't forget to give me a thumbs up. Subscribe so you never miss out on a video. And if you have any questions that you'd like answering, please just drop them underneath and I will try and reply. Otherwise, thank you very much for watching, everyone. Bye for now.